I'll just go through the roll call again. Samuel Mills, are you present?
Present, Your Honor.
Great. Thanks, Mr. Mills. And then Rebecca Mills, are you on the line?
Yes, I am. Sorry about that.
Great. Glad to have you here. And then Ms. Looney is present and Ms. Day is present.
Yes, Your Honor.
One today for Mr. Mills' motions related to parenting plan and child support modification. Maybe we could hear first from Ms. Looney related to child support, the state's position, and we'll hear the position from the other parties.
Your Honor, at the last review, we did ask for a copy of any child support order that Mr. Mills was presenting to the court. We did not receive that. Child support will only be impacted if Your Honor grants the change of placement for the children. Our request at that time would just be for a bench order to end support as to Mr. Mills with him having custody of the children. It was the state's understanding that Mr. Mills was not requesting support be entered regarding the mother. We would just need to have an order in place if there is a change regarding the need for an end to support. Excuse me.
Thank you, Ms. Looney. Okay, Mr. Mills, why don't you go ahead with your motion? I'll hear from you related to the parenting plan, and then let's pause on the child support argument until we address parenting plan. So we'll hear your argument on the parenting plan, then we'll hear from Ms. Mills, and then we'll hear from Ms. Day.
Yes, Your Honor. I'm asking for temporary change of residence for my two sons for 6 months to be readdressed at 6 months. I believe, given information, that living with me is the safest and stablest environment. Just starting off with her domestic violence evaluation, the summary, it states that she's a problematic risk for telling the truth, emotionally abusive and manipulative. It recommends that she gets a substance assessment, takes some parenting classes on top of the 6-month DV classes. She met a guy online and within 2 weeks moved in with him, and then took the kids and slandered my name, ran me through the mud, said that I did all this and that and that, and none of it was true. And I lost my kids. I had no contact with them. For 2 months. I then got supervised visitations every other weekend when there was no need for all that. It was just her manipulating the state and trying to remove me from the picture so she could have new daddy step in. She and her boyfriend recently broke up, and he informed me that this behavior that I experienced with her has continued. The manipulative behavior, such as she would egg him on with her phone out ready to record him so that she could pretend to be a victim. And she would verbally abuse his 3-year-old in front of our children, such as saying, "Get the hell away from me, I'm not your mother." And she would call him names such as, pardon my language, but fat, to his 3-year-old son. And this was in front of my children. He's also stated, her ex-boyfriend, that her continued behavior to neglect the children, such as sit on her phone all day and ignore them, continued. And she stated to me before that this was when we were together, she stated that she can't handle our son Oliver, which is our youngest boy. Her ex-boyfriend stated that she told him that as well. And when he throws a tantrum, she just lets him do what he wants. And that would be like, he'll walk outside by himself, go sit in the car, and she'll leave him in there for hours.
And Oliver's 4 years old?
He is now 4 years old.
Thanks.
And she would do that just because she didn't want to deal with him. Recently, after she got her DV evaluation, she stated to me, because she was trying to get me to say that she doesn't have a drinking problem, but in that same conversation, she told me she doesn't know how to relax without alcohol. And another example of the manipulation is we made our own parenting plan to work together and try and make this more civil, something that worked for both of us. All we did was we agreed we would keep Tina Day's original recommendations and just move the holidays around. And when I went over to sign the parenting plan, that's what she told me. She said, it's exactly the same as what Tina Day put. We just changed the holidays. So I gave it a quick glance over, signed it. Well, her ex-boyfriend brought to my attention that she took off the no new relationships for 6 months, and she did that intentionally. I don't want a rotating door of men in and out of my kids' lives. She doesn't know these men before she's ready to move in with them. They could be terrible people that could harm my children. And I know that I believe this is going to be a continued behavior for her to just keep moving from one guy to the next. And I don't want my children around that. I've maintained my house. I've maintained my job. It's very stable, very safe where I live. And as stated by the state, I did file if I am given temporary custody of my children. I don't want child support from her. I just want what's best for my children.
All right. Thank you, Mr. Mills. Appreciate that.
I'm sorry. Can I do one more thing? I forgot.
Yeah, go ahead.
They are in school, and I know it's going to be brought up that how am I going to take them to and from school? Because I work a day job. Yes, I would leave before they have to go to school. I have a very strong family support system that can help get them to and from school. And my sister already picks them up after school and babysits them. So her childcare is my family.
Okay. All right. Thank you, Mr. Mills. Ms. Mills?
Yeah, I wrote something down. Is it okay if I read it?
Sure, that's fine.
Okay. I don't believe Samuel is looking out for the best interest of the boys. When he found out that we were living with my parents after a breakup, he didn't reach out and ask how the boys were doing or anything. He did ask me, however, 3 days later to lower his child support amount by $200 a month and take me to court over concerns he didn't care to speak to me about prior. He's been supporting his girlfriend through college right now, but wants to take support away from his children, in our time of need. Samuel has also said on many occasions that he will sign off on the current custody arrangement if I pay him the amount he's asking in our divorce, which I think is like $3,200, something around that amount. It's all about money to him. There's a lot of information in Samuel's declaration and parenting plan that is not true, and events in Robert's messages that never took place. I loved Robert's son, LJ, like he was my own, and I'm still in contact with him through his mother. Samuel also has our children's schedules wrong. He can't even get them to school. He can't get them to school with his work schedule and his girlfriend's school schedule without his mother spending the night or driving from way out Rose Valley, which can't be maintained long term. Secondly, he states he handles all medical and education, which is a lie. I've done all of that since day one for 4 and 6 years. I've provided written statements from both of the boys' teachers that show that Sam has never made contact with either teacher. He's never handled it. I have. And thirdly, I have an incredibly strong bond with both of my children. I was a stay-at-home mom their whole lives until 2 months ago. So we're more bonded than most parents and children today. Both of these men supported my role as a stay-at-home mom because they know I'm an incredible mother until I wanted out. Our boys go to Samuel's sister's house after school every day, and Samuel knows in his heart that if his sister saw any signs of neglect or mistreatment, that his sister would take a stand and back him. But she sees nothing but 2 boys who love their mom and their mom who's doing everything humanly possible to do the right thing for her children. I do worry about Oliver's temper tantrums. It's the same ones I witnessed Sam throw in our 7 years together. I fear he will grow up and follow in Sam's footsteps. The difference is that Oliver has 2 parents who love him and so many family members who adore him and show up for him. Sam didn't have that growing up. I believe Samuel and I should both be taking parenting classes to help Oliver navigate his big feelings. I think it would benefit Oliver greatly if we were on the same page. And because Sam went into such great detail, I never allowed my 4-year-old to go sit in a car for 2 hours ever. My son, Oliver, he has big feelings. And when he has big feelings, he isolates. That's what he does. That's what he's done since he was about 2. He'll go sit under a table and he'll cry his big feelings. And then he'll go, mommy, mommy. And I know, okay, he's ready for a hug. He's ready. He worked through his feelings, and I've seen many specialists about this. We worked with Progress Center about it. I worked with his teachers, and they say that's great. He's self-soothing. He's working through it. On one occasion, I watched him go out to the car. He was out there for 10 minutes. He buckled himself in his seatbelt, and I was there. I was sitting on the front porch on our porch swing, and he was in our driveway. It was not a hot day. It was a cold day. I've never put my children in danger. And I have a home of my own. In 2 months, I got a job. I bought a car. I got a house. Sam wants to say I'm mentally unstable and all of these things. And, I think I'm doing all right. I'm okay doing any of the things in the DV assessment. He had things in his DV assessment also. So, yeah.
Where are you in your progress in the DV?
I was waiting for it to be ordered. I'm in counseling just for my own self. this court process. And he said, I drug him through the mud. You know, he's drugged me through the mud. It's kind of unfortunately what happens sometimes. It's taken a toll on me. So I'm in therapy. But as far as the DV counseling, I haven't started.
Okay. And what's your position related to Mr. Mills' request for no exposure of the children to new romantic interest for a period of time?
I am perfectly okay with that on both ends. I'm okay with that. I agree with that.
Okay. All right. Thank you.
I do think that it would be detrimental to the children to move them. They went through 2 big moves in the last month and a half. The last 2 months they moved, you know, he was my fiance. They moved from there to my parents' house with me, and now into a new house. And, you know, we've maintained routine. Their teachers say they're doing great. I do think another big move would be detrimental. And I don't see how he can get them to and from school. I don't see how he can do it. I can do it. My work schedule is very flexible. Like I said, I've been a stay-at-home mom for 4 and 6 years.
All right. Thank you, Ms. Mills.
Thank you.
Yes, Your Honor. I have not had a lot of contact with the 2 parties since I issued my report, but I've had some. They were working through an agreement when mother's relationship ended suddenly. This is kind of a short-term relationship. This is the relationship that mother left the marriage for. And the children stayed with father during that time until mother was situated, and then she took the children. What father reported is accurate. I do have some concerns because many of the same allegations that were lodged by the most recent partner are similar to what father experienced, and some of what was discovered in my investigation and by the evaluation that was done. I do think mother should begin immediately in the domestic violence treatment. I think there should be absolutely no consumption of any kind of non-prescribed substance. That has been an allegation on both sides that has been kind of back and forth. And I think that that poses a risk to these children because neither of these individuals are able to be completely aware of what happens when they're using substances. I think father's made good steps since he has been down this road for the last couple of years, but I don't believe that mother has. I don't believe she takes it very seriously. I have requested for several months for the children to be engaged in therapy to help them with the sudden transition and the loss of their father that they experienced at mother's request or behest, however she wants to word that. They have not been in therapy. The youngest child did receive some services from Progress Center, but they were very inconsistent and were discharged without receiving all the therapy that was needed. So this is not a case where, you know, the parents were super active. Mother was active in getting this child the services that they need. The services were needed. There was some compliance and mostly there was no compliance. So both these boys need therapy. They need to have some support emotionally to help them with all of these changes. This is the 3rd big move in a very short period of time, part of which included a loss of their relationship with their father. Father remains in the family home. If the court makes a decision to change custody temporarily, it would be the family home that the children are accustomed to. They are there a significant amount of time each month now, once those allegations were proven to be not accurate. So it is true mother has been the at-home parent. I think there are a lot of concerns about that, and it's difficult to know how much of that is true or not true, or if it's just a regurgitation from the newest partner that the relationship has ended. I am absolutely strongly opposed to any exposure to significant others as well. That was the crux of the problem with the initial separation and what these children experienced. So I will leave the decision about temporary change or not to you, but I have a lot of concerns and I'd like to see these boys get the support and help that they need. Both parents are working. Both parents now have their, mom now has her own residence, but I don't know about anything else from that perspective. So,
Do you see any specific dangers in either home to the children?
The danger in mother's home is a partner's. Mother does have a tendency to go from immediately from partners that she's met online and then move in with them and move the children in with them. I think that's the biggest concern. I don't see any concerns with substance abuse other than what I hear was admitted and in the domestic violence evaluation. And then the other concern would be the domestic violence. There is a lot of dishonesty, a lot of manipulation, and that has continued throughout this investigation. And I would agree that mother should start that within the next 30 days. That needs to be addressed and moving forward.
All right, thank you. All right, Mr. Mills, you've heard Ms. Mills was able to hear your argument and then respond to it, and now you've heard her argument. I'll give you just a few moments to respond to her arguments.
I guess this isn't about money to me at all. I was hoping to touch on this at the end of the case, but since it was brought up, the debt that I'm asking for from her, I don't even want it. What I want from her, I want one thing, is I was court ordered to take a drug test, and if it came back negative, Rebecca would pay for it. That's all I want when it comes to debt. This isn't about money to me. I don't want child support. I don't care if she pays our debt or not. I just want a safe and stable environment for the kids. I've maintained the family home. I've maintained my job. I've been as consistent as I can be with my boys, given the restrictions of when I'm allowed to see them. It's just very difficult because Rebecca has tried to erase me from their lives multiple times, to the point to where she would have my sister watching them, and I dropped by on my way home for 15 or 20 minutes to see my boys, even though it wasn't one of my designated days. And Rebecca found out and then was threatening me with contempt of court, which I'm not breaking any rules seeing my boys. I don't have a stay away order for my boys, but that's where her mindset is.
All right. Thank you. Appreciate everybody's input. So
Right.
the last parenting plan was entered on July 19th, 2023, where it indicates Ms. Mills is the custodial parent and father has weekly residential time during the midweeks, and then also alternating 3 weekends per weekend, Friday to Sunday. So I think Mr. Mills' suggestion and request that Ms. Mills involve herself in a substance use disorder evaluation as recommended by the domestic violence evaluator is well taken. So Ms. Mills, you're ordered to obtain a substance use disorder evaluation with collateral input, meaning Ms. Day could chime in, Mr. Mills can chime in addition to the input that you give. Also, a parenting class was recommended, such as Love and Logic, as recommended by Ms. Lovely. You're required to do that. Regarding the domestic violence, that evaluation has already been completed, so you're ordered to commence that. We'll set a review in 30 days to make sure that you've commenced in those efforts.
Are we ending here? Or are we? I'm sorry, because I had something else on a declaration that I submitted.
Yeah, we're ending. I've given everybody an opportunity to share your verbal thoughts. I've read all of your pleadings that you submitted. So I'm giving my ruling at this point. So I'm not taking any additional content from the parties. Thank you. So we'll be back here on February 7th at 9 a.m. to review progress of the domestic violence treatment, the SUD evaluation, and any recommended treatment, and progress in the parenting classes. The request for no romantic interest exposure to the children is well taken. That'll apply to both. That'll be for a period of 9 months. So you meet somebody, and then 9 months from that date of meeting would be the first opportunity that the children would be exposed to that individual. So that'll be an order. Related to the change in parenting plan, the concerns that I'm hearing is that from Mr. Mills' perspective, that Ms. Mills is making an effort to keep him on the sidelines or reduce his impact on the children's lives as manifested by prior actions. There's concerns on his end about the treatment of Oliver, and Ms. Mills has given her response to that. There's also concerns related to alcohol consumption, and both parties need to be careful on that, obviously. So I'm concerned about the stability of the children moving in and out of different homes. That's obviously a big concern, second or third big move in the recent past. The parties, when they were together, had made a decision that Ms. Mills would be the primary custodial parent at home, while Mr. Mills would be the primary breadwinner. And things obviously have changed. Now the parties have separated. However, I'm not going to make a change related to the parenting plan. I think the children's best interests are there's indications that they're threatened in the best interests are threatened in Ms. Mills' home. However, I'm ordering the SUD evaluation, the domestic violence classes, and the parenting classes as support, and hopefully there'll be some changes on that. We'll watch that carefully as we move forward to see if there's any additional concerns that are come up. So I'm denying that request, so the July 2023 parenting plan will remain. There was a motion related to tax exemptions. The parties didn't address that in your verbal comments. I did read that in your written materials. And so for the tax year 2023, Ms. Mills, you can claim Oliver, and Mr. Mills, you can claim Emmett for the tax year 2023. So that'll be the court's order related to that. Any questions or concerns or clarifications on the court's ruling? Did you have something?
No, thank you, Your Honor.
No, Your Honor.
Okay. One moment, please. So from my perspective, I'm just speaking with my assistant. There's nobody in my waiting room. So they may be in the wrong waiting. All right. So I will, as far as the tax exemption, I'll put that into writing and I'll create an order that memorializes that. And I'll also include I'm just jotting myself a note here. I'll also include the denial of the change to the parenting plan. And I'll also include the SUD parenting class and the DV, and then the review date, which will be February 7th at 9 a.m. Okay. Good morning, Mr. Denlocker.
Good morning.
Heather Lucor, are you on the line this morning?
Yes, I am.
Okay, welcome to you. And Ms. Looney is present, and we are here. Let me get my notes for a moment. Okay, this is related to a motion for temporary orders. It looks like the restraining order has already been addressed, if I'm not mistaken. And there's at issue our parenting plan. And this was a little confusing procedurally, and I think I've got it clear in my mind. But there's one proposed parenting plan that's scheduled for today. There's another date noted for the 24th, which relates to another proposed parenting plan. My sense is that we're going to be addressing them both today. Is that your understanding? I'll touch base with Mr. Denlocker and then Ms. Lucor.
Your Honor, I'm asking for a continuance. I've been sick since before Christmas. It started with a sinus infection, and then I got COVID. I'm still very sick right now. Heather has been not being able to be reached for all the papers that I've served her with. I've emailed them to her. Friends of mine have gone to her house. I've had paperwork in since the very beginning to Heather Lucor, and she has not received any of it. I'm just, it's all been documented with the court, filed, and she has not read or gone over any of it. I've asked with my restraining order for a hair follicle test. She provided the court after being told by the judge our very first court date that she would give her another week. And she provided a UA instead, which you only have to be clean for 3 days.
So let me touch base with you, Mr. Denlocker. You're making a request to continue this hearing due to illness. Tell me how and then you kind of mixed it with service issues on Ms. Lucor. So is it that you're too ill to proceed today, or is it that the illness interfered your ability to prepare for today's hearing?
I'm not well, and nor has she received any of my paperwork that I served her with, attempted to serve her with days after she was served with the first paperwork, with the ex parte restraining order and proposed parenting plan.
Okay, so let me touch base with Ms. Lucor. Ms. Lucor, are you raising any concerns related to you being served documents, or are you indicating that you have been served documents from Mr. Denlocker?
I have not been served documents other
I missed
than
that first part. Could you repeat that?
Yes. I have not received any documents from him. I also have been home quite often, as well as I have a roommate that has been here the last 5 days, pretty much all the time. I actually have messaged Ryan ever since the restraining order has been dropped. I have messaged him multiple times. I actually just messaged him again, I think it was 2 days ago, telling him I have not received any paperwork at all since the first paperwork he filed. I do have that in text message proof. I told him I also have not received any emails. I have not had anybody try to serve me papers. I asked him if we could somehow set up a time to make sure that I am home, or make sure that he has the right email address, because my email address is printed on the paperwork. So I don't know how he could possibly be getting it wrong, but I have not received anything from him. Ever since the restraining order was dropped, he refuses still to let me have any contact with my daughter, our daughter, sorry.
Well, I don't want to go too far afield in this. We're talking about the request for continuance, and I asked about the service of documents, so I appreciate your input.
Okay. Sorry.
No, that's okay. Ms. Looney, do you have any input regarding the continuance and service of documents and the like?
There's no objection on the state's part for a continuance, Your Honor.
Mr. Denlocker, what time frame are you looking at as far as continuing?
I already put in a request for the 24th. If we could just continue with that, that would be wonderful. If Heather can tell me a time that she can actually be served with the papers that you guys have already stamped and it's been filed. It's been in for quite some time.
Okay. All right, I'll grant the motion to continue the matter. There, obviously, the service of documents is important. The parties can work that out amongst themselves. And we will be here on the 24th at 9 a.m. to address the issues that have been raised by the parties.
Thank you, Your Honor. I really appreciate it.
May I ask a question?
You may.
Is there any way I can have contact with her?
So in granting the continuance, I'm not hearing the merits on the issues related to parenting time or residential time. The parties can come to an agreement, then that can happen, obviously. And obviously, I don't think there's any restraining orders that prevent Ms. Lucor from having contact with the child. Obviously, if a child is being withheld, that's obviously frowned upon. But if there's other reasons for that, that's something we can address on the 24th of January. So granted the continuance, I'm not getting into the merits as far as visitation. So we'll see everybody on the 24th. Are you on the line today?
Thank you, Your
Yeah,
Honor.
I am.
Okay, welcome to you. Stephen Scrimshire, are you on the line?
Yep.
Okay, welcome to you. So we're here on a motion for parenting, a temporary order on parenting plan. And it looks like child support was entered, as Ms. Looney indicated, back on December 6th of 2023. One thing before we get into the kind of substance of things, I was checking to see if the documents that you filed, Mr. Scrimshire, if you had served those on Ms. Nolan.
I did.
Okay. And did you file a proof of delivery or declaration of service, affidavit of serving her those documents?
I'm not exactly sure if I did. If I remember correctly, I don't think I did.
Yeah, I think your memory is correct, because when I was looking through the file, I don't see that there was that declaration where you say, or a third party says, hey, I served such and such documents on Ms. Nolan on such and such a date. I don't see that.
Okay.
So that makes it difficult for us to proceed on any motion without Ms. Nolan being given copies of those documents. So before we hear the case, we would need to have those documents served to her, and she would have an opportunity to respond to your submissions. So that's kind of a long way of saying that we're not moving forward on the motion today.
Okay. So I did serve her with everything except for that one part. So that's the only thing I need to get in.
So I'm not exactly what specific documents. I could probably look through and make a list, but there's multiple documents that if you're going to be addressing them, or if it's part of your motion anyway, what you're asking for, then those are the documents that would need to be served upon her. And then that proof of service would have to specify, hey, these are the documents that were served upon her on such and such a date.
Okay.
And then Mr. Scrimshire, do you have any questions about the child support order that was entered on December 6th?
I do.
Go ahead.
So as of right now, I'm in the middle of trying to get a job. But right now I don't have a job and I don't have a income.
Mhm.
And there's no way that I will be able to pay what they're asking me to pay for the child support. I was hoping maybe we could do like a payment plan or lower the child support for right now until I can support that income that they're asking.
Okay, thank you. Ms. Looney, do you have any response?
Your Honor, Mr. Scrimshire can contact the Division of Child Support and ask to speak with his support enforcement officer, and they can set up a payment plan with him while he is seeking employment.
Okay.
All right, so I'd encourage you to do that. Hopefully that could provide some relief and also provide for support, continued support for the kids. So I'm not sure as far as what we were here on the 6th, the child support order was entered at that point in time. Without the documents being served on Ms. Nolan, I'm not exactly sure what time frame to move this case to. So Mr. Scrimshire, do you have an idea of when those documents may be served upon Ms. Nolan?
I can get it all done as quick as possible. Sometime this week.
Okay.
I have a question. Is there any way that I don't want to keep pushing this out, but seeing as I'm the only person that's working and I can't keep taking time off to sit and wait for 2-3 hours for court right now and not work. I don't know, it's just starting to get really annoying. If we can just push it out a little bit, honestly.
Okay. So I think what we'll do here, I'll encourage the parties to do is that we'll encourage Mr. Scrimshire to serve those documents upon Ms. Nolan. And then once you've effectuated service, then you can file what's called a docket notice. And then you provide notice to Ms. Looney and to Ms. Nolan and setting it upon one of the specified family law dockets on a self-represented docket. So I'll leave it up to the parties to take care of that. And so I will not set a current date. I'll let the service occur, and then once that's occurred, Mr. Scrimshire, then you can set what's called a docket notice, which puts the case officially on a docket, and then we can address those issues.
Okay. I'm sorry. I missed the very first half of that. My phone reset and then I got back onto the meeting.
Sure. I indicated that you'll need to serve Ms. Nolan with the documents that you filed related to your motion. Once you've served her with those documents, then you'll file the proof of service document with the court. And then at that same time, you could submit what's called a docket notice. A docket notice is giving notice to everybody saying, hey, we're going to come back to court on such and such a date. So I'm not going to set a date right now because service is somewhat unsure when that'll occur. So I want to make sure the service occurs, and then the docket notice can be sent out, setting a date for the matter to be heard. Does that make sense?
Okay. Yeah, that works.
Okay. Ms. Nolan, do you have any questions?
No, that's good.
All right. Well, we'll wait for the proof of service to be filed with court and then the docket notice. And then once that's set, we will hear the matter and address the issues raised. Thanks, Mr. Kudlicek. And Ms. Knowles, are you on the line today?
Yes, sir.
Okay, welcome to you. And I see that Ms. Corey is present as a guardian ad litem. And this is related to visitation, a request for a change. And so I'll hear from, I believe, Mr. Kudlicek's motion.
It was actually my motion, Your Honor.
Thanks, Ms. Corey. We'll hear from you first then.
In the last visit with the child and Ms. Knowles, there was a physical altercation and an assault. Still unclear whether that's being moved forward with charges or not. However, I have at least 3 police reports where different officers have been called out for physical altercations between Ms. Knowles and the child. And most recently, Judge Warning ordered a UA for Ms. Knowles, which came back positive for marijuana, methamphetamine, and amphetamine use. And my ask at the time was for this to go to some sort of supervised visitation, which Ms. Knowles disagreed with and refused to do. So Judge Warning then cut visitation for the time being, which is where we're at now. I still believe that supervised visitation is going to be the safest for the child at this point. And I also believe that Ms. Knowles should get a substance abuse evaluation.
All right. Thank you, Ms. Corey. We'll hear from Mr. Kudlicek and then Ms. Knowles, please.
Yeah, I believe supervised visits will probably be the best way to do it, just for the fact that they seem to not have, they seem to can't get along very well. And I tried to talk to her why, and she doesn't really want to, well, my daughter doesn't really want to talk to me. Why she just kind of keeps to herself when it comes to her and her mom, which is kind of okay. But I just want them to be able to be able to send her down there and not have to worry about if the cops are going to get called or, you know, if there's something's going to happen to her. You know what I mean? Other than that, I have no issues with anything like that.
Thank you, Mr. Kuzlachek.
Yeah, I want my visits back, and it's not me assaulting my child. It's Aza assaulting me. The first time, she gave me a black eye.
See, Ms. Knowles, it looks like your audio kicked off or stopped.
In the face.
So Ms. Knowles, go ahead and start again.
I didn't hear you. What?
Your audio cut out, and so I wasn't able to hear what you were saying. So I was inviting you to start again.
Oh, sorry. No, what I was saying is that it's not me assaulting Aza. It's Aza assaulting me. The first time she gave me a black eye, she ran away. This last time she shoved me down 27 stairs and she punched her little brother in the face because she was asked to take her dogs out. She's been being aggressive. I've reached out to try to get her help with her aggression for over a year. That's why she's on a deferred disposition from her first assault when she assaulted me in June. I don't agree with having supervised visits because I don't have the money to pay for supervised visits. It's Aza getting mad and her being told that she can use her safety plan. And if she doesn't want to do something at my house, that's what she says. She's using her safety plan and she turns aggressive each time she has. And I also don't agree with our court being posted on Facebook. And in our court order, it says that Chris is not supposed to be speaking with Aza about the court case when he's showing her videos and she's messaging me, telling me that Chris is showing her videos of our court. I mean,
I didn't know those were on there. I was showing those the other day.
That's you doing what the judge said not to.
So I invite the parties not to crosstalk, just speak directly to me. And so,
Yes,
Mr. Knowles, you have the floor.
Okay, well, I do not agree with someone leaking. I don't know who it is because I've filed paperwork. Someone has leaked this whole court case on TikTok and Chris is showing our daughter. And I have the messages from her about what he's saying. And it's not okay. When he is fighting against it, he's putting that barrier, saying, oh, your mom's doing this, your mom's doing this. When I'm not, when it's getting posted online, I don't even social media. And just the fact that this all started because Aza assaulted me and the judge told her that she got consequences to her actions and she didn't want to do it and she ran away. And this is how this all started, from her putting her hands on me and going to jail.
Okay. All right, thank you. So here there's concerns related to the visitation and the time that mother and daughter have together that has resulted in at least 3 police contacts. Certainly it takes 2 to tango. One is an adult, one is a child. So
there's only one
responsibility. So Ms. Knowles, I'm giving my ruling and I encourage you not to crosstalk each other and I encourage you not to crosstalk me. Is that understood?
Yes, sir.
Thanks. So with an adult, there's a greater responsibility to safeguard and promote relationships and protect the child. And I tend to find that illicit substances and mind-altering substances diminish an adult's ability to care for a child and work through relationship difficulties. I find also that when persons are spending money on illicit substances or mind-altering substances, those monies could have been spent elsewhere, for example, on supervised visitation. So I think here that there's significant enough concern related to the physical safety of the daughter, combined with information that the window was potentially screwed shut, so she couldn't get out. And I can understand why a parent might do that, but certainly that raises a safety concern if there were to be a fire or a need to get out of the house quickly.
CBS saw it.
So Ms. Knowles, do you remember what we talked about before and that you agreed to and that you said you understood that you wouldn't interrupt and crosstalk?
Yes, sir.
So sometimes if you can't remember that, just hit mute and then I won't have to hear you when you're interrupting me as I've instructed you not to do. So there's an indication also that Ms. Knowles' significant other potentially has a substance use disorder or addiction that's active and not treated currently. So I am going to grant the motion related to the professional visitation professional supervision of visits for Ms. Knowles. So that'll occur one time per week, up to 2 hours. Ms. Knowles will be responsible for paying that. Video visits can occur one time a week, separate from that, up to 30 minutes. If the parties can't agree, that'll be at a Wednesday at 7 p.m. for the video visit and up to 30 minutes. And that Ms. Knowles will need to get a mental health evaluation with a parental risk assessment and also get a domestic violence evaluation. And if there's any recommended treatment, fulfill and complete that treatment. So that will be the court's order. Any questions?
No, Your Honor.
Ms. Knowles, any questions?
Yes, what can I do about my court being posted online with about him going against the order, telling Asa all this court stuff? Like,
Yeah, that's concerning, Ms. Obviously, involving a child in the court proceedings is not healthy for the child because there's an alliance that they feel toward each parent. So encourage the parties not expose the child to the court proceedings and let the adults deal with it. So there'll be Wednesday, so supervised visits, one time a week, up to 2 hours. And that's effective immediately. And then the domestic violence evaluation and then a mental health evaluation required for mother. All right.
Your Honor,
Yes.
sorry, I apologize. Did you intend to include a substance use evaluation also?
And if I failed to state that, that's, yeah, definitely. So in addition, Ms. Knowles will need to get a substance use disorder evaluation, follow up with any recommended treatment. Those things, those evaluations will be key to expanding your visitation time with your daughter. That'll conclude today's hearing. I'll draft an
I have
order.
a question, Your Honor.
visitation.
Mr. Kudlicek, you had a question, then we'll hear from Ms. Knowles.
Yes. Is there what time on Wednesday do we do visitations and like where at and anything like
So
that?
Wednesday, it'll be via video visits. So
Okay.
FaceTime or
Okay.
other means. So, and then the supervised visits need to be professionally supervised, and the professional supervisor can help establish that.
Okay.
All right, that'll conclude the hearing. Thank you.
Thanks, sir.
Thank
You
Your
just
Honor.
said,
Oh, Ms. Knowles, I forgot you had a question or you wanted to say something. Go ahead.
yes, like, how do I, can you repeat what you said needs to be done and what, like, is our next court date next month? Is that what's going on? Like,
Sure, I can definitely repeat that for you. So,
and I'd also like if I can get the school information, like I was supposed to be told and I still haven't been told nothing for school.
so related to your first request, you'll need to get a substance use disorder evaluation and do any recommended treatment. You'll need to get a mental health evaluation with a parenting risk assessment included. You'll need to get a domestic violence evaluation and follow up with any recommended treatment. You'll have professionally supervised visitation one time a week for up to 2 hours. If the parties can't agree on a date and time, Saturday at noon. And then there'll be a video visit during the week, midweek, for 30 minutes. And if the parties can't agree, it'll be Wednesday at 7 p.m.
Okay, so all this, the stuff that you just said that I had to do, Chris was also judged or ordered by a judge to do this and was never done too. So can we get that done going for him as well too? Because Oregon, the state of Oregon, put all that same exact stuff in for him when we had our case back then and it was not done.
Okay. So my focus today is on the current order. Other issues such as that, it would need to be the subject of a further motion. So that'll be the conclusion of today's hearing. Thank you.
Your Honor,
Yes.
I apologize again. So my final review is supposed to be the 25th of this month with these orders that you've asked of Ms. Knowles. Would you like to push that out?
No.
I don't see any reason to hold a hearing that's so close in time to today's hearing, because if Ms. Knowles gets an evaluation set up within the next week or so, generally those evaluations are not turned around in a single week. So if the hearing is set for that future date, you said, what date did you say?
Actually, the final GAL review is supposed to be the 25th of January. Oh, excuse me, the 24th.
24th. Okay. So we're about 3 weeks out from that date. And I don't think it's reasonable to have a hearing on that date with
I do. My daughter, I would like to see my daughter for her birthday.
Well, the issue is we're talking about the next court date. So I'm going to strike the 24th and let's move that out roughly a month. We'll move it out to February 28th at 9 o'clock in the morning. We'll make sure that works for everybody. February 28th at 9 a.m.
Yes, sir.
Yes.
Okay, what about Chris?
Ms. Knowles, will that work for you? Ms. Knowles, February 28th, will that work for you?
I'm looking at a calendar right now.
Okay. Wednesday at 9 a.m. Okay, so I heard an affirmative that will work. And Ms. Corey, does that work for you?
Yes.
Okay, we'll see everybody on February 28th. Thank you for raising that issue. Are you on the line today?
All right. Thank you, Your Honor.
Yes, sir.
All right, good morning to you, sir. We're on today for a presentation. It looks like there was a hearing on December 21st, and that Ms. Fisher would be drafting an order and then showing that order to Mr. Fisher. And then it looks like the order the hearing was on the 28th of December. And Ms. Fisher, you had the order, but Mr. Fisher had not yet seen it, so we set it over 1 week. And so I was looking in my file to see if I had a copy of the proposed order, and I don't see one. So where do we stand with that order?
Yes, Your Honor. I gave Sean the order when we were doing our drop-off, and he has it with him. He's looked at it, but it has not been signed or filed yet.
Okay. So, Mr. Fisher, with that order that was presented to you, do you feel that it accurately portrays what the court ordered back on December 21st?
Yes, I do.
And sometimes when parties agree that the order accurately reflects what happened, they will simply sign off on it and give it to the court for filing. Is that the party's plan here?
Yes, it is.
Okay. Have you signed it, Mr. Fisher?
I have not signed it yet. It's sitting in my lap right now.
Okay. Could you tell me what your plan is as far as signing it and getting it filed with the court?
That is my plan, to sign it and get it filed.
As far as a specific date and time, can you give me a date and time where you think that will happen?
It's kind of hard because you guys close like before I get off work, and I work Monday through Friday, so I have to leave work early. So I'll have to figure it out.
Sorry to interrupt, but if Sean wants to sign it and return it to me for 1 hour drop-offs, I can file it. The next time I see Sean will be Friday.
Okay. Would that work for you, Mr. Fisher?
Yeah, that works.
Okay, so let's do this. Let's just set a review date on February 16th to make sure that the order has been filed. If the order has been filed, then we can strike the hearing on that date and we won't need to talk about it. But if it hasn't been filed, then we can talk about it. Does that work for the parties?
Yeah, that works.
Yes, I just have one question, Your Honor. When are we going to be discussing the divorce and the child support?
So generally cases are driven by the parties as opposed to the court. So if a party is seeking for some type of relief, then they would file a motion asking for a parenting plan or child support or dissolution or property distribution. And that would be filed with the court, and the date would be docketed and set. So we generally rely upon the parties to move the case forward.
Well, she served me with all the divorce papers, the dissolution and the child support and everything, and I've responded.
Okay. And then Ms. Fisher, have you selected a date for your motions to be heard?
No, I have not, but I will absolutely do that when I go and file the parenting plan this week.
Okay. All right. And then when you do that, just make sure that Mr. Fisher gets notice of the date and time of that hearing, and then we can reconvene and address those issues.
All right. Thank you so much, Your Honor.
Okay. Any final questions, Mr. Fisher?
Nope, that's good.
All right. We'll set the review for the 16th. We'll assume that we can strike that. But we'll
Yeah,
wait
I had
till that
trouble
date and make
getting
sure
on.
everything is filed. Okay. Welcome to you. And Mr. Kozar, are you still on the line?
Yes, I am here, Your Honor.
Okay, great. Thanks for your patience. And Ms. Turnbull, you're still with us?
Yes, I am.
Okay, perfect. All right. Let me just bring up my notes. All right. So I saw that there was a hearing back on December 6th, and there was an indication that Mr. Kozar needed to be enrolled in a domestic violence program and a parenting class. We're going to review that and potentially moving to some type of different visitation. So not exactly clear on the kind of the procedural history, but that's kind of the glimpse that I've been given based on the records. So maybe Ms. Turnbull, you could explain your understanding of the purpose of today's hearing.
Yeah, that's my understanding as well. The parties, I think, are wanting to
to expand Mr. Kozar's visitation. But the concern has been that he did not follow through with, and I think maybe he had a misunderstanding with the recommendations that were in the domestic violence treatment evaluation. He thought they were recommendations rather than things that he really, needed to follow through with. And so the ask at the last visit was that he, in fact, follow through with getting established with the domestic violence treatment and take the parenting class, and that, once he's established, then we can revisit expanded visitation. And to be honest, with the holidays, I have not heard from him and followed up with him to find out where he's at with that. So we'll need to ask him today.
Thank you, Ms. Turnbull. Mr. Kozar, what's your input on the issues?
I was more than willing to get all of the treatment done that was recommended, even though I don't see it as necessary. I've been currently seeing my son with Haley's multiple times throughout the week. And I've enjoyed it. That's all I want, is to just be able to spend some more quality time with my son more than anything. I tried reaching out to Olivia, which was the one I got my assessment from, and I have reached out to her twice, I believe, and I haven't heard anything back. I think it's probably because the holidays and all the New Year's that was going on and whatnot, but yeah, I haven't heard anything back. I will be reaching out today as well, just to, I'm wanting to just get everything over with so I can just see my son more, because I was wanting at least weekends, even though I would like more than that. But I mean, if I could start with weekends, that would be awesome. I know I'm a great dad and a good influence on him. We always have a really good time when I'm around with my son as well. So that's all I'm really focused on. Is I just would love more than anything to have actual quality time to spend with my son, as well as on Sundays with my visitations. It's supposed to be 4 hours, but for a while now, my grandma, I'm not sure if she's necessarily sick of me going there or how to explain that, but every time I can go there to do the visits with her, she only wants us to be there for 2 hours. So I'm getting what seems even less time with my son the further this drags on. And I just would like some actual quality time with Jackson is all.
Thank you, Mr. Kozar. Ms. Lawrence?
Yeah, I agree. He should have a little more time with him. I'm hoping we can get it to where he has a overnight or weekend or something.
Okay. All right. Thank you. So it sounds like, Mr. Kozar, you're taking steps in the right direction to get some of the items that have been ordered previously completed. So it sounds like the domestic violence, you've reached out to Ms. Lovely to get that started and engaged in that process. So that's fantastic. And then where do you stand as far as the parenting class, whether it's the love and logic or the children in between?
Like I said, I reached out to her to try to get recommendations, because I'm trying to see if I can not pay out of pocket for a lot of this, because
Sure.
I just recently found out going to the substance abuse, I somehow have health insurance, which was kind of nice. So I'm just trying to find somewhere that can possibly cover with my insurance, so that way I'm not having to pay out of pocket for going through all this stuff, because it's hard enough as it is with my schedule being Monday through Friday, Saturday on call. I live out in Cathlamet and my office is all the way out in Beaverton in Oregon. So I'm mainly, always up early, home later in the day for the most part. So it's a little hard for me to get something situated, but I have been trying to reach out and just get all this over with, because like I was saying, I just want some good quality time with my son, honestly.
So when you mentioned you're reaching out to Ms. Lovely regarding the classes, just because it sounds like you're needing information about where the classes is, how to get signed up, correct?
Uh-huh.
Okay.
Yeah.
All right. So it sounds like Mr. Kozar is engaging in the SUD treatment. That's appreciated. He's reaching out to Ms. Lovely to get engaged and start with domestic violence treatment. That's appreciated. And so hopefully he can get the class information and start those, notwithstanding our busy schedule. So I think we're still things are looking up, and so I think one way to look at this is to set a review not too far out, to make sure that Mr. Kozar is engaged in those services and some type of feedback about his performance, how things are going with those particular services, and getting set up in those services and getting some feedback. Meaningful feedback often takes time, so I'm proposing either a 4 or 6 week time period to review the case, and I'll just get feedback from the parties. Ms. Turnbull?
I think that's reasonable.
Okay, Ms. Lawrence? Oh, sorry, Ms. Turnbull.
Oh, no, that's fine. That's good.
Okay, Ms. Lawrence?
Yeah, the sooner we could do it, the better.
Okay, and then Mr. Kozar?
Yeah, I'd be okay trying to get the 4 weeks just so we can try to speed this up if that's possible.
Yeah. Okay. Let's do that. I sense from Mr. Kozar that you're going to get on this stuff and get moving with the different classes and services. So we will set this over to the 7th of February for review of status. So what I'd encourage you to do, Mr. Kozar, is that if you can get any type of updated information from your SVD counselor, some document, and then file that with the court. Same thing with Ms. Lovely. Once you've engaged in the treatment, have her just indicate where you are in treatment and what she's seen. And if you've completed any of those classes, please submit those to the court to show us what you've done. And also, of course, send copies to Ms. Turnbull and Ms. Lawrence. And then we'll be here on the 7th of February at 9 a.m. to review your progress and take a look at expanding visitation at that time.
Okay, that sounds good to me. Thank you.
Okay. All right. Sounds like we're all agreed on a plan forward. So we'll see everybody on the 7th. Hopefully we'll have some good updated reports and we can expand the visitation.
Okay, thank you.
Thank you, Your Honor.
We're here today on Ms. Teff's motion for contempt. And procedurally, let me just make sure if I understand where we're at. It sounds like there was a contempt order filed against Mr. Teft back on November 15th, made by Commissioner Carmi, related to the $3,100 in the tax return. And so she made that finding of contempt. Then there's a motion for reconsideration filed by Mr. Teft a few days later on the 21st of November. And then Commissioner Carmi stayed the contempt order on December 13th, and we're still awaiting a ruling on the motion for consideration. That's my understanding. Is that your understanding, Mr. Swenson?
Yes, Your Honor, that's my understanding. The contempt that was filed on November 15th was stayed, and the petitioner filed another contempt seeking jail time on December 15th, but it appears to be about the same issues. And I think we're still waiting personal service on that.
Okay. Thank you. Ms. Morris, that rehearsal of the procedural history where we've been kind of just in the recent past, does that ring true to you?
As far as I'm concerned, I thought that when the reconsideration was already decided when she decided that the court was going to stay, but apparently from what I'm hearing, it sounds like that was just for the contempt in November.
Yeah, that's right. So the contempt order was made, and then the commissioner said, I'm putting that on hold for a little bit, and while she works on giving a ruling on the motion for reconsideration. So the motion that we're on here today seems to be duplicative of the prior contempt order, asking basically for the same thing. And since that order is still being contemplated via the motion for reconsideration, I'm of the opinion we should strike today's hearing, wait for the outcome from Commissioner Carmi on the motion for reconsideration, and go from there.
Do we know when that's going to be?
No, we don't. The motions for reconsideration are somewhat difficult to know when that'll occur, because commissioners and judges have regular dockets, and then they have to find time separate and apart from those dockets in preparation for those dockets to work on appeals, summary judgment motions, writing opinions, responding to motions for reconsideration and the like. So I don't know. I know Commissioner Carmi is very conscientious about timeframes. So I don't think it would be very long, actually, but I can't give you a specific date and time. So I think that's what we'll do at this point in time, is that we'll strike today's hearing because of the outstanding or pending motion for reconsideration. And once there's an order from Commissioner Carmi on that issue, the parties could note up whatever item that they think is appropriate. But at this point, I'm striking the motion for today because it is duplicative of, and it covers the exact same ground that was covered by the contempt, and the motion for reconsideration are the same.
Okay. I have a question. How many times can they keep doing the reconsideration thing? Because I feel like this is like the second or third time they did that, when I have two judges already agreed that for him to pay the stolen money back. So I'm just confused on this. So I'm curious how many times they're going to do that reconsideration, or how many times can they do that?
So once an order is made by a court, a party can file a motion for reconsideration. Once that order has been made, you cannot ask for an additional motion of reconsideration on the reconsideration that you've already done. So anytime that there's a new ruling, a motion for reconsideration can be submitted.
Okay, thank you. I was just wanted to clarify that. I'm sorry.
No, the questions are always welcome. Mr. Swenson, any additional items today?
Your Honor, as the court's aware, I was appointed as approved for 10 hours. This is now the 5th contempt motion asking for jail time. So I've expended over 40 hours on this case. Should I submit a written motion or can I do an oral motion now for approval of 10 more hours?
Thank you.
I think it would be helpful for the accounting department and the like to have a written order. So if you would be so kind to submit that, that would be appreciated.
Okay, thank you, Your Honor.
All right, thank you. All right, that'll conclude the hearing. Thank you. Oh, did you have a question, Ms. Morris?
Yeah, I just want to say, I found an attorney that I'm gonna have represent me. How do I submit paperwork with her, or have her submit the paperwork?
Okay. All right. We'll wait for her input, and then whatever filing she addresses, we can take a look at.
Okay, so right now we're just waiting for the decisions, and then once the decision, the reconsideration decision is made, then we'll go from there with as far as my attorney and all that.
Yes.
Okay.
Beth Fellows.
Okay. Thank you.
Thank you so much.
She's a guardian ad litem. She's a professional supervised visit person. I've already started the process with her, but on work I put to be determined because I didn't talk to her yet, but I just talked to her, and I'm turning in that paperwork today.
And are you referring to this proposed order transferring case to mandatory mediation?
I think so.
Information on
It was to respond to him,
Okay.
but if we don't have to do mediation, then I can just do Beth Fellows.
Meaning she would serve as the mediator, is that what you're saying?
Yeah, for supervised visits.
Okay, so there's a couple different things to clarify, just make sure I'm clear. So supervised visitation or supervised supervisor of visitation is separate and distinct than a mediator. A mediator's job is to hear from both parties and help parties come to an agreement on issues that you don't agree on. Could be parenting plan, it could be child support. And so that they try to encourage the parties to do a little give and take and then come to an agreement. And then once there's an agreement, then the parties can sign off on it. And that's different than a professional supervisor. Professional supervisor provides supervisory services of a parent while interacting with their child.
Yeah, and she's a guardian ad litem too.
She is a guardian ad litem also, which is a separate role, which provides kind of the eyes and ears of the court to report back on what's happening with a child in a particular household or with parents. So with that kind of that foundation, let's hear from Mr. Hicks. This is your motion as far as transferring the case to mediation, correct?
Yeah, well, actually, I tried doing mediation before I even turned in the declaration on this case. I offered to pay for it, and she was not willing to do it at all.
Okay.
I'm willing to do whatever I have to do to see my kids. It's been a long time. I'm in recovery. I live in a clean and sober house. My parents they're certified through the state for foster. So I was wondering if I do have to do supervised visits, if they're willing to be there. I got a job. I've tried contacting Miss Sarah and her husband for months now about seeing my kids, and they've turned me away every time. I'm in drug treatment. I graduated TRC. I got a job. I'm doing everything I need to do, and I'm just whatever it takes to see my kids. That's where I'm at.
Okay. So let me make sure where we're at procedurally on this. So there's a couple of things that are going on. One, there's this motion to transfer the case to mediation. That's kind of what we're here formally for.
Okay.
And what I'm also hearing is that you have a desire to have some type of visitation with your children, and hasn't been resolved yet.
Not at all. I've tried and I've get turned away every time.
Can I say something?
Yeah, go ahead.
We also had CPS involved, and they told me that I had to leave him. Otherwise, my kids would get taken away, and he was not allowed around him until a judge okayed that.
Right.
I also have all the paperwork from when I had protection orders on him. He has cases of stalking me. So that's why he was not allowed around, if we're being honest.
Sure. So it sounds like there's obviously some history within your relationship that things happen, and it sounds like Mr. Hicks is making some changes in his life, and so it sounds like he's desirous to have some type of supervised visitation. So that motion is not before us today. If that's a motion you want to make, then you'd have to to write out a motion specifically stating, this is my parenting plan that I want, such as Ms. Farmer submitted a proposed parenting plan. She said, this is what I think the parenting plan should be. This is when visitation should occur. These are the limitations and the like. Have you done that?
I started it and then had her served with papers, and then this was her respond to that.
Okay, so let me just double check. So I see in the case file, Ms. Farmer submitted a proposed parenting plan December 14th. And then on November 29th, you filed your proposed parenting plan.
Right.
So we kind of have the idea that both parties have an idea of what the parenting plan should be.
Yeah.
So kind of the next step in that process is to bring a motion for temporary orders or a motion to enact one of the parenting plans. And then we have come together with your declarations, your reasons why it should be your parenting plan as opposed to the other party's parenting plan. You can support that with declarations from people who are familiar with the situation and the children. And then I would read all of that, would come back again another date where you would orally kind of summarize your position with me having read all the documents. Ms. Farmer would do the same. And then I'd make a decision on the parenting plan kind of moving forward.
Okay, so like documents from like our families or what?
Yeah, declarations can be from anybody you feel that has relevant information.
I have one from her family right here.
Yeah, and so those are documents that you can file. What's important to remember also that when people file declarations or statements, they have to be made under the penalty of perjury. There has to be that language included, otherwise the court cannot consider it. So sometimes people will submit like an email that one of their supporters sends to them, but it's not written, I hereby make this declaration under penalty of perjury. If it doesn't have that language on it, it can't consider it. So it's important. Some people forget that. So that's kind of where we're at. It sounds like from just talking to you a little bit this morning, the motion to transfer the case to mediation, that's kind of why we're here today.
Mhm.
And it basically says, Susie, I'm a little confused about that because I have a document here filed December 14th from Ms. Farmer that says she's asking for an order transferring the case to mandatory mediation. That's why I'm a little
I just
confused.
got the papers from the emergency support shelter.
Okay.
But if we could do this Beth Fellows, we both pay the $100 intake fee and then 45 per hour. And we won't have to be around each other.
And is this Miss Fellows services that's related to hopefully coming to some type of agreement related to let me finish. So that's hopefully using Miss Fellows will allow both the parties to come to an agreement related to a parenting plan?
Yes.
Okay. So,
Your Honor,
Ms. Fellows?
yes. I would like to offer a little bit of clarification, if I may.
Please.
So Ms. Farmer has contacted me a couple of times actually, and it's about supervised visitation. It is not about mediation or anything else. So I just wanted to clarify, it was only about professionally supervised visitation.
Okay, that helps.
Yeah.
Right. So there's a lot of moving parts in a case, and we usually try to take bite-sized bites rather than eating a whole donut in one swallow. So it sounds like there's a request to go to mediation that you're making, and there's Ms. Farmer is doing a kind of another related piece where she's saying, let's go have supervised visitations for you and is it child or children?
Children.
Children. Okay. So that's a proposal that she has. That's not formally before the court today. That's something if the parties want to work on that, you can certainly work on that. But for today, let's focus on this mediation thing that's before us.
I will pay for both of us to go to mediation if that means I can see my kids.
Okay. So the parties, I'll draw your attention to the court rule, and you can just go to the Cowlitz County Superior Court website, which is cowlitzsuperiorcourt.us.
All right.
Pretty straightforward. And if you do a Google search, you'll find it.
All right.
And then once you're there, up on the top row, they have subheadings, and one of the subheadings says home, schedule, forms. Another one is rules. So you click on rules, and then you just click on the drop-down menu, which is local rules, and you look for rule number 93. Rule number 93 is the mandatory mediation rules for parenting plans, which I think you're probably both familiar with. If not, you can read that. So before you can get a trial date, you have to go through mediation, at least make an effort to resolve the case in mediation.
Yeah, when I talked to a mediation person, they actually suggested that we do mediation before we even did these parenting plans.
Sure. Yeah. And that's the idea, is that it's better if you two, who are much closer to the situation than I am, can figure out a solution to the issues that involve your children.
Right.
If you can't, after trying, come here and I'll make the decision and hopefully help in that process. So that's kind of where we're at.
Okay.
So with the mediation services, I'm going to grant the motion to engage in mediation. I think the parties are probably kind of getting a little bit closer. I mean, it sounds like there's been some difficulties in the past, but maybe there's a corner being turned, maybe not. I don't know. Yeah.
Is there any way I could at least like make a phone call to my kids? Like they haven't let me talk to my kids in 3 years.
They don't even know him.
Like when they found out that I moved over here and got clean, they blocked my family, which was having current visits with them, going to their birthday parties. They blocked every one of my family members. When they found out I seen my kids 3 years ago at my mom's house, they took all visits away from her. Like I'm doing everything I can. And like, I'll at least have a phone call for 15 minutes, maybe, like to start off. Even like, it's been a long time.
So just in response to that, when there's been an extended absence for whatever reason between a parent and their children, what I've seen generally happen in the past that allows for kind of a trauma-free or a nice, good transition is to have some type of transition plan in place that's thought out and considered. And I don't know if we can give it enough thought and consideration on today's docket to make sure that that happens. That's something in mediation that I think could happen, that you talk about how to do a transition plan that would work really good for the children and work well for the parties. I think it's important if people are making changes in their lives that they be given opportunities to re-engage. I think that's important. That's kind of the essence of life. We make horrible mistakes and we make a lot of improvements, hopefully. So that request, I think, is a ripe topic for mediation.
Okay.
So I would encourage the parties, you can contact go to that Rule 93, and that will give you information. Sister's got it, I guess.
Yeah, my sister.
Yeah.
So it's in Cowlitz County.
It's calissuperiorcourt.us. So the motion to send the case to mediation, I'll sign off on that.
Okay.
And require the parties to mediate and do all you can to accomplish that. So the proposed order I have from Ms. Farmer indicates the mediation services would be paid 50-50.
Yeah.
Are you comfortable with
He
that?
just put just me on there.
I'll pay both of them. I don't, if whatever gets us started.
We'll do 50-50. And then the parties are going to mediate the following issues: parenting plan, and also I'm going to check here kind of a transition reunification plan.
I just had something. So it's great that he's getting clean and doing what he needs to do. And I think it's great that he wants to see the kids. But I would ask that we slowly transition into it, because my kids don't know him. Our youngest is 4 years old and has no idea who he is. He didn't even get their ages right or spell their names right on here. So I think a slow transition would work best for my kids.
So that's part and parcel of this mediation as to the parenting plan. And so I did specify transition and reunification plan as something that should be addressed in the mediation.
Perfect. Okay.
Right.
And that's through the Community Mediation Center. They're located, I believe their address is on Commerce.
Yeah, I know where they're at.
Okay. And then it asked me to put down the petitioner's name. So that's Ryan Lee Hicks. So I'm just going to put this information here. And then what's the best mailing address? Signing off on that order. All right. So I signed off on that. I'd encourage the parties to contact the Community Mediation Center and get that rolling on this order. If you need a copy of it, you can check with the clerk's office in a day or two and get a copy of it.
Okay.
Any further questions?
Now, do we need that copy to go down there and get it started? So I go down today then, or?
I think you could probably go down and contact them today and we can get set it up and they can get a copy. Because they have access to Odyssey, which is the court filing system, so they can look up any documents.
Yes.
Okay. Well,
All right, thank you.
Thanks. And Jeffrey Brooks, are you on the line? Jeffrey Brooks.
Yes, I'm here.
Okay, welcome to you, sir. All right, we're here on a motion to invalidate or annul a marriage. Let me just pull up my notes. And this is a motion brought by Ms. Blanchard, and it's also joined or signed off on by Mr. Brooks. Is that accurate?
Yes, Your Honor. And I'm just here to ask for it to be stricken from the docket.
Okay. And Mr. Brooks, do you have input on that?
I agree with her, sir.
All right. So we will strike it from the docket. We won't let me just double check with the parties. One would be to just strike it, and you could bring this motion again, or not bring it again, and just let it lie and just let things sit. Is that kind of what you're wanting to do?
Yes, we
Yes,
want
sir.
to remain married.
Okay, Mr. Brooks, is that your position also?
Yes, sir.
Okay, all right. I will strike the hearing.
Thank you.
Thank
sir.
you so much.
All right, thank you.
Have a wonderful day.
Person in the waiting room, they just popped in. I'm just going to double check. Angelique Brower, are you on the line? Angelique Brower, are you on the line? Okay, so a couple things to start off. I know Mr. Wade through past association at church, and it's probably best, I think, just from an objective viewpoint or objective standby viewer viewpoint to recuse myself, since we've had past relationship association. Before I file that recusal, I just wanted to make mention that it looks like there was service effectuated on Ms. Brower on December 8th. But I had a question, and Mr. Wade, and maybe you can address this. The declaration of service indicates that a petition to invalidate marriage was filed, a summons, notice of hearing, and a declaration. So it looks like, okay, so I think that answered my own question. I thought you hadn't served upon her your own declaration, but it looks like you had. So with my recusal, we'll need to set this to we'll need to set it to a conflict docket. And Madam Clerk, can you help me on which docket that would be? I'm not sure. Do we put that onto a just an A or B docket?
Yes, based on that, it would be a morning.
Morning.
Tuesday at 9.
Tuesday at 9. Okay, Mr. Wade, would you be available next Tuesday, the 9th at 9 a.m.?
No, I should be.
Okay. All right, let's set it over to that date. The record should reflect that Ms. Brower, her name was called, and I'll call again, Angelique Brower. If you're on the line, please state your name, make sure you're unmuted. At this point, Ms. Brower, if you have spoken, I haven't heard from you. So the record will reflect that she's not here, and we'll set it over to that date related to the motion or the petition to invalidate. Any questions, Mr. Franklin? Mr. Wade, sorry.
Yeah, so Tuesday at 9 a.m., is that still a Zoom docket, or would you like me to come in appearance?
Zoom is an option for that docket, so it's your preference if you can appear via Zoom or in person.
Okay, I'd love to come in person.
Okay. All right, the court doors will be present. Monique
Okay.
O'Brien, are you here today? We'll see you then.
Yes, I'm here.
Okay, welcome. And Brandon James, are you here today?
Yes, sir.
Okay, welcome to you, sir. And then Ms. Corey is also here as the guardian ad litem. I think we're here today for an interim report of the GAL report, if I'm not mistaken, Ms. Corey.
Yes. Unfortunately, I have not been able to move this case forward very much. I have met with Ms. O'Brien and also reviewed her hair follicle test that came back negative. But I have had trouble getting intake documents from Mr. James. I did, after hours yesterday, receive those documents. There's about 4 pages missing from that, but I'm just going to try to move forward from this point and go ahead and set up a initial meeting with Mr. James to move things forward. My apologies.
Thanks for that update, Ms. Corey. I appreciate that. Mr. James, so it sounds like Ms. Corey got some documents yesterday that's encouraging, and it sounds like she also needs an opportunity to meet with you to work on her report. Is that something you're in a position to coordinate and get that taken care of?
Absolutely.
Okay. All right. And Ms. Corey, do you have his contact information?
I do.
Okay. All right. So it sounds like there's more information that Ms. Corey needs to digest. She's got some information from Ms. O'Brien, and then she needs to get additional information from Mr. James and also take a look at those documents that came in late yesterday. Ms. Corey, do you have a time estimate that you think would be reasonable to meet, digest, and write and present?
Is the court looking for a written interim?
Not necessarily. Looks like you were appointed back on November 8th to address issues of mental health, substance use disorder, safety of the child. Generally, those can be addressed verbally.
Okay. And I don't recall if there is a date set for a final review.
I think there, well, let me double check.
Yeah, February 28th.
February 28th.
Yes.
All right. With that in mind, what is your suggestion, Ms. Corey?
Can we do perhaps a verbal interim around the first week in February, and then maybe move that final review out a few weeks?
Okay. Ms. O'Brien, what do you think about that?
That's fine. I just would have to know an exact date so I can get it off work.
Right, right. Mr. James, what do you think about that proposal?
That works.
Okay. So why don't we move this interim GAL report giving to February 7th, Wednesday at 9 a.m. So that'll be the interim verbal report from Ms. Corey after she's spoken with Mr. James and digested that information, having spoken with Ms. O'Brien. We'll strike the February 28th date as far as a guardian ad litem final report. And would it be untoward, because if we have the interim report on the 7th, would it be better to have 30 days or say 45 days for the final report to be given? Ms. Corey, do you have any sense on that?
Just kind of based on how many reports I have due in that time frame, 45 would be better.
Okay, so that would be the 20th of March coming back. So does that work for the parties to come back on February 7th for the verbal interim report at 9 a.m. and then March 20th at 9 a.m. for the written final report? Ms. O'Brien?
Yes, that works.
Okay, Mr. James?
Yes, sir.
All right, so we will set that in stone. February 7th at 9 a.m. will be the interim report verbally. The 20th of March at 9 a.m. will be the written final GAL report. We're striking the February 28th date. Don't come then, but we will see you on February 7th and March 20th.
Okay. Does that mean the restraining order is staying?
I'm making no changes to any existing orders. So basically just did some scheduling here today. So no changes from what has been happening and has been previously ordered.
Okay.
All right, Mr.
And then
James.
real quick, Your Honor, that February 7th, is that a 9 o'clock as well?
It is, yes.
Okay.
All right. All right, thank you all.
So we're
Appreciate
on
your help.
today
For a pre-trial for a trial of on a modification of a parenting plan that's set for the week of January 22nd this year. And we also have a readiness hearing on the 16th of January at 11:30 that will determine this precise date during the week of the 22nd that the trial will be heard. So as far as pre-trial generally is a time in which it's a time of preparation to make sure that everything is ready for the trial and that all information has been exchanged between the parties, documents, witnesses, contact information of witnesses has been provided. So let me just touch base with the parties. Ms. Hall, do you have an idea of what individuals you may call as witnesses during the trial?
I do. I have about 4.
Okay. And have you provided those names and the phone number to Mr. Sorensen?
No, I have not.
Okay.
I thought that's what we do here is voice it to you guys. So I wasn't sure how to. Okay.
Sure. I mean, you could do it one of two ways. Doing it verbally here is helpful. But sometimes some things are lost in the translation, if you will, and that's why the written word sometimes it works a little bit better. So those 4 individuals, who are those 4 individuals?
It'd be my husband, Joseph Fike.
Okay.
My father-in-law, Ed Fike.
Okay.
My sister, Haley Gomez.
Haley Gomez, okay.
Gomez, and my mother, Jill Hall.
Jill Hall. All right. Mr. Sorensen, any questions related to those witnesses that were potential witnesses?
No, Your Honor.
Okay. And I'll ask the same question to you, Mr. Sorensen. Do you have, who are the individuals who may be potential witnesses at trial?
I'm not calling on any witnesses.
Okay. So you just yourself?
Yes, sir.
Okay. All right. Then let me ask the parties, the main contention or the issue to be solved at trial, Ms. Fike, can you tell me what that is?
I'm so sorry. Can you repeat that? You cut out.
Sure. At the trial that's coming up near the end of January, what's the main issue in your mind that needs to be resolved, that needs to be sorted out?
The reason why my son refused and ran away from his father's house. I want to get down to the bottom of what's going on over at his dad's house and why he doesn't want to be there.
Okay. So it's the issue of parenting plan and timeframes and the like, and figuring out why.
Yeah.
Okay. And Mr. Sorensen, what's your impression of what's to be resolved or presented at that trial?
Of changing the parenting plan that we have in place right now.
Okay. All right. Oftentimes people will come to court and they will have documents that they want the court to review and be part of the evidence that's presented. Do either of you have any documents either from financial institutions or from counselors or guardians ad litem or evaluators that you want the court to consider?
I submitted my son's counseling records. I don't know if you need to talk to his counselor or not. I'm not sure how that works.
Generally at a trial, the individuals need to be called as witnesses to testify as to what their personal knowledge is of a particular issue. So if a counselor, you want the court to know about that counselor, then you need to call them as a witness. If there's no objection to the records being considered from the other side, then the court can consider those records. But if they object, then you would rely upon the verbal testimony of the witness to get that information in.
Okay.
So that's something to consider, is that if you have documents that you want to have admitted, you can ask the other party. You can look under a rule, it's called Evidence Rule 904, that you can use that rule to say, hey, these are the documents I want to have considered during the trial. And you can send those documents to the other party and have them look over them. If they object, then the court will rule on it at trial. If they don't object, then they say that's okay. Then those would be admitted and considered during the trial. So that's something you might want to take a look at and file what they call an ER 904 submission or an Evidence Rule 904. And you can look that up online.
So as far as the paperwork that I have already filed, do I need to refile that as for everything that I've filed up to this point?
So declarations
for evidence.
Yeah, if you have your own declarations, you can testify and cover that information with your verbal testimony. If you have other documents that come from a third party, you may give consideration to having those submitted through the ER 904 process, or calling that individual as a witness during the trial.
Okay.
Ms. Corey, I saw you turned your camera on.
Yes. If neither party is calling me as a witness, I can strike this from my calendar.
Let me hear from the parties. Ms. Fike, Ms. Corey has indicated that you've indicated that you're not planning on calling Ms. Corey as a witness. Is that accurate?
Yeah, that's accurate.
Okay. And Mr. Sorensen, do you plan to call or potentially call Ms. Corey as a witness?
I would like to call on Miss Corey as a potential witness.
Okay. Then at this point, I would like to ask for my typical fee for trial, and that is 2 hours trial prep and 1 hour trial testimony.
Okay.
That's fine. Is that an order that you could just briefly submit via email and I could sign off on it? Or is that something I could just do a bench order?
A bench order would be fine.
Okay, so let me just give myself a little note here. And that would be 2 hours prep time, 1 hour trial time. And what's the rate?
$150.
Thank you. I'll prepare that order and submit that.
Thank you.
All right. And so thinking about the trial, just any additional items or questions, Ms. Fike, that you have in preparation for the trial that you would like to clarify here today?
I don't think so.
Okay, Mr. Sorensen?
Other than, she's threatening to go against what a residential schedule is now. So if I was to file another contempt, it would more likely be granted outside of the trial. Is that something that could be brought into this trial if that was the case?
So at a trial, you're welcome to raise any issue you'd like that you feel is relevant to the issues to be resolved. The court or the judge that's hearing the case may say that's okay, may say that's not okay to bring in alleged contemptuous behavior. Some people will file a separate motion based on an allegation of a contempt, and that could be heard separately from the trial. So it's not certain whether the judge would allow you to bring that evidence into the trial. She may not.
Okay, thank you.
Any other questions in preparation for the trial? Thanks for your patience. Thanks for joining us today. We'll next see you all on January 16th at 11:30 for the readiness hearing.
Thank you.
Yes, sir, I'm here.
Thank you. Okay, welcome to both of you. We are here today on Ms. Casciato's motion for adequate cause pertaining to a parenting plan and a request to adjust it. Before we get started, let me just take a quick moment. So there was procedurally where we're at, there's allegations from Ms. Casciato that Mr. Miracle struck the son, and then there was a hospital visit at the end of November. There's investigations from CPS and law enforcement. There's a restraining order, I understand, is in place. And on December 14th, there was a suspension of Mr. Miracle's parenting time. At a hearing on the 21st of December, there was a continuation of that suspension. The restraining order was denied. And then the parties were instructed to provide as much information as possible prior to this hearing, whether it be from CPS, the police, or what have you. And there was maybe some confusion as to the date, whether it's the 3rd or the 4th. When I looked at the file with that as a background, I was looking for updated information that was possibly filed from the parties, and I didn't see any. And so I just want to make sure that if the parties did file something, that you let me know about that, because I didn't see any. So I'll hear first from Ms. Casciato.
Hi, I tried to get a hold of the detective on the case. The police and the CPS case investigation is still ongoing, but Detective Scallingsberg went on a medical leave for 2 weeks, and I'm not sure if it's a forensic interview or not. I've left them a few messages and haven't heard back. I haven't heard anything back from CPS. At our hearing on the 21st, Mr. Miracle said that he had served me some papers through the mail on the 20th, but I've never received those. So I'd like to know that he can serve me through email, because I haven't gotten anything through the regular physical mail.
Okay. All right. Thank you. Mr. Miracle, do you have any updates or any documents that you had filed related to updates?
Yes, sir. So I was able to finally make it in up there yesterday to file 3 declarations. I don't have a current email address apparently for Rebecca. So I was forced to have her dad served. So it was sent to his email.
Okay. Is that something that if you had Ms. Casciato's email address, that you could send those same documents to her?
Yes, sir.
Ms. Casciato, what's your preference as far as sharing your email address? Do you want to do a direct chat message to Mr. Miracle, or do you feel comfortable doing it in open court?
I can do it in open court. It's the same. It's always been.
Okay. Did you get that, Mr. Miracle?
Yes, sir. That's the email address that was served initially.
Okay. And just as a precautionary effort, or maybe double effort, would you mind sending those same documents that you sent to I think you said one of the fathers, and send those same documents to Ms. Casciato?
Yes, sir.
Okay, that would be appreciated. All right. So I think where we're at, so we have this pending adequate cause motion related to the modification of the parenting plan, and we're still collecting information. Really, there's been no new information, I think, since the hearing on December 14th. It sounds like there's some medical leave issues, some forensic interviews that may or may not have been completed. And we have Mr. Miracle, who's submitted some new information apparently yesterday that hasn't hit the case file as of yet. So that's kind of an expanded way to say, I don't think we're ready to hear the motion, because there's no new real information to share on the issue. So my proposal, and I'll hear from the parties, is to continue this matter for a future date where there's a reasonable expectation, where we'd have some documents and have something of substance to review that would allow us to address the adequate cause motion. So I'll hear from Ms. Casciato, as you're the moving party.
Yes, when I did speak to the detective last was in December, and he said it would be at least the early or mid-January before they'd have any new information. The forensics interview was sent through physical mail rather than electronically, which would take a little more time Plus, he would took the 2-week medical leave, so he just wasn't available. But I expect to get a hold of him within the next couple weeks and get some sort of an update.
Okay. All right, thank you. Mr. Miracle?
Yes, sir. So, seeing as how there's been absolutely no move, and there's honestly, I mean, even with the medical person, I'm not sure who would, the medical evaluation, they even stated that they weren't sure if it was abuse or not. They said that the only thing they stated was that the bruises didn't come from normal play. And the entire time he was over with me, he was hyperactive the entire time. I tried to explain the bruises to Rebecca, but this is where she decided to take the entire issue. I was completely communicative with her the entire time. I'm asking that the suspension of visitations be revoked or dismissed. I've already lost Christmas with my son over allegations with absolutely no proof, and there will be no proof.
May I say something, Your Honor?
So you may, but I was just going to jump in and just say we're talking about a potential new date, and so yeah, I'll hear from you, Ms. Cachado.
This all started when the child had reported to me that his father had punched him, and he had a very large bruise on his side. So I took him into the hospital here, and he said the same exact thing to the nurse that he said to me, that his father had punched him.
Thank you. I was aware of that from reviewing the file. So Mr. Miracle asked the court to remove the suspension of his visitations based on some information that I think was in the file where they indicated that they were uncertain if it was abuse, that they were normally bruising that didn't occur during normal play and the like. And so that he's asking for those visits suspension to end. So I'm not in a position I guess I am in a position to lift that suspended visit. From Mr. Miracle's viewpoint, he's done nothing wrong. He did not abuse the child, and he's lost time, and he's going to continue to lose time under that suspended visit, and that's wrong and not right. Under Ms. Cachado's viewpoint, her child was abused by Mr. Miracle, and she's seeking remedy through law enforcement and other channels. So what is obviously clear here is that there's some uncertainty. That's kind of the key word. There's uncertainty as to what did or didn't happen. And without more information, I think I'm going to err on the side of caution. While that does inflict a lost time for Mr. Miracle with his child, and the lost time's hard to make up, I recognize that. But I think I'm going to err on the side of potential safety and wait and continue today's hearing and set it out to if mid-January is kind of the time frame the police are indicating that they might be able to have something done, then if we were to come back on February 7th at 9 a.m., that should, if they have something completed, then that could be distributed between the parties and filed with the court for consideration. So that's where I'm thinking of going. And then you had a question, Mr. Miracle.
Yes, sir. All right. So this isn't the first time that these types of accusations have happened, especially around Christmas time. This is the second time I've had my son taken from me. I've had multiple throughout this. Sorry. So we went to trial. I was ruled in favor as the primary, and due to the scheduling that the guardian ad litem had suggested, that was ruled in favor of. I decided on going with the 2-week on, 2-week off visitation. But prior to that, so I mean, I'd showed like so much flexibility and like consideration and understanding towards, Rebecca's situation, and like I'm not trying to provoke her in any which way, shape, or form, just because it's she's very good at manipulating the system. She's very good at making accusations and playing the victim. And she's earlier on in her mental health evaluation that was ordered by the court, it was even stated that she does not admit to her own wrongdoings. She tries to manipulate the situation into that will play into her favor with her being the victim. That is all false.
So hold on. Let me just ask Mr. Miracle a question. My indication was that we are going to move this case to February 7th to get more information. And you're telling me that there's been a history of fabrication or efforts to prevent you from having time with your child. So I'm not quite sure where you're going with your comments, because I've indicated that we're going to set this matter over to February 7th for more information. I'm not sure if you're asking for an earlier date or a later date, or what the purpose of your comments is at this point.
I'm sorry. I'm just frustrated. I've had my kid taken from me so many freaking times, and it gets frustrating, and especially because this is supposed to be a court of law. And I don't understand how people can get away with doing whatever they want to do, even though it's wrong, and using the court to basically hurt somebody.
Okay. All right. Well, thank you for sharing that insight. The hearing is set over to February 7th at 9 a.m. and hopefully we can resolve this soon. So we'll say everybody's February 7th at 9 a.m.
All right, thank you.
All right. Thank you. Sunderland, are you on the line?
Yes, I'm present.
Okay, I see you, Mr. Sunderland. Welcome. And then Nicole Tomlinson, are you on the line today? Nicole Tomlinson, if you're on the line, please make sure you're unmuted and state your name, please. Okay, so Ms. Tomlinson is not present. We're here on a motion for temporary orders related to parenting plan and child support. And I see that Ms. Tomlinson had signed a joinder. And a joinder is a document that says, hey, I agree with what the other party's asking for. She also indicated that she wanted to be sent notice of any hearings that are occurring. So a docket notice was sent on December 8th for today's hearing. But the address that Mr. Sunderland used was not the address that was on her joinder document, which is the Beacon Hill address. Right. Instead, Mr. Sunderland used the Eugene, Oregon address. So generally, and this may seem nitpicky, but generally Washington is a notice pleading state where documents are filed, and if addresses are on file until that's changed, that's the address that we need to use. So what I'm based on that, and I appreciate, I think probably what Mr. Sunderland was doing is that Ms. Tomlinson had moved and he's like, okay, well, I'm going to just use the updated information and send it to her at there where she'll get it, right? Where she's located. However, under this notice pleading statute and where everything's in the file is kind of the official notice of where things need to be sent. The docket notice for today's hearing was not sent to that joinder address where she said, hey, I'm fine with what he wants, but just give me notice and send it to my Beacon Hill address. So until she changes that, that's the address that needs to be used. Mr. Sunderland, does that explanation make sense to you, whether you agree or not agree with that?
Yeah, it makes sense, but she's moved 3 times since we split up, and she is what seems to be to me intentionally avoiding being served. I have documentation from a Emerald City Legal in which it stated that they talked to her on the phone, and she said that she was going to come pick up the paperwork, and she failed to do so.
Right. I did review that in the pleadings that you filed. And so there's some sense that may be happening. So generally what I've seen people do as far as when there's a joinder filed by somebody and they say, this is the address you need to use, and that there's a new address, usually people will send it. They'll include more addresses than just the official one. So they definitely include the official one, which is the Beacon Hill address. And then they may include others where the individual may be, and they send those documents there. So that gives a greater potential of, number one, fulfilling with kind of the letter of the law using the Beacon Hill address, and then also allowing for potential notice to be given at the other addresses where she may have moved. So I think that's important to note. And so based on that, I don't think we can move forward with the motion today because technically service has not been effectuated, even though it was sent to the Eugene address of the docket notice. So my suggestion would be that Mr. Sunderland, if you want to move the case forward, which it sounds like you do, would be to send a docket notice for a date in the future to the joinder address that's on file, and send it to any other addresses that you think would be appropriate. But the key one is the joinder address that's noted in the case file.
Okay.
And so that would be, you would send that docket notice, you'd file that with the court, and you'd also send it to her of the upcoming hearing date. And then if there's any proposed orders, that you're proposing, that would be appropriate to send her copies of those also.
Okay.
So that's kind of where we're at. Do you have any questions with regard to all that?
No, not really. I'm just frustrated because I've been trying to establish a parenting plan, basically just to keep my daughter safe. I'm not sure if you've had a chance to review any of the evidence or if you even can, considering that it wasn't served. But it's a situation where the new, basically what I was trying to do was propose a new temporary plan so that basically things were safe when she would go to visit her mom, and her mom didn't try to withhold her or cut off communication or anything silly like that, really detrimental. But it's just a tough situation because her mom is not following through with anything when she had wanted to join the other parenting plan. We basically got to the very end of it, and then she moved spontaneously, and then she just moved again like 3 weeks ago, and it's just been very hard to follow through with any of this to safeguard my daughter. And so it's just an ongoing struggle, I guess.
All right. Thank you, Mr. Sondland. I appreciate that perspective, and thank you for being here today. So I think with that information that I shared with you as far as the joinder address and docket notice, we'll likely see you here in the future on your motion.
Okay.
Tiffany Rooks, are you on the line? Mr. Sondland, thank you.
Yes, I am, Your Honor.
All right. Thank you.
Thank you, Ms. Rooks. And Gareth Clark, are you present today? Gareth Clark?
I don't think he is. I haven't seen him. I've been watching.
Thank you, Ms. Lawrence. I appreciate that. And Ms. Karen Lawrence, the guardian of the item, is present. This is Ms. Rook's motion related to a motion to modify a parenting plan. I think it's to end or suspend visits. And also your motion to be able to claim tax exemptions for the tax year just recently concluded, 2023. So before we proceed, I just want to touch base with the parties as far as service of the documents related to today's hearing. So let me go into the case file. I'm looking at the declaration of service filed on December 7th, 2023. So I look at it says proof of personal service. It says my name is Daniel Phelps. I'm not a party. I served court documents for this case to Gareth E. Clark II by giving the documents to Gareth Clark and Tammy Sharp. And it says date and time and address of service. It says date 12/ nothing in the middle /2023 at 11:06 a.m. And it's signed and dated December 7th. So I don't know when he was served.
He was served on, it was on the 7th. I'm not sure why he didn't put the date in, but it was the 7th. And when we went to court back on December 20th, she ended up making a court date for this date because she was like, well, do you want to have her pick out a court date, or do you want to just go with the one that I chose? And he said, go with the one that the previous judge had asked to bring forward, which would be today. So he was served. He did make it to the last court date 2 weeks ago on the 20th.
Okay. And have you had any communication from Mr. Clark, whether he's going to be here today or not?
When I ran into him yesterday, he was aware of court. He even said that he was going to be there. And so this is an ongoing issue. He doesn't show up for court. This is the second or third time he's missed court. He doesn't turn in any documents. And I can't move forward, at this point, I should be able to move forward and get things, done that it's going to benefit my children. And we're just kind of stuck in a hard spot right now because he doesn't want to cooperate with anything that the guardian ad litem has requested him to do. I requested him to do. The last judge had asked him to do. He just doesn't want to put forth the effort to do anything.
Okay. Thank you. Ms. Lawrence, do you have any input related to the service issue or what happened at prior hearings?
I am aware that he was served. He did discuss it with me when I spoke with him after the last court, when I committed in court to provide him some documents and things, but I haven't had any further contact with him. It's very concerning because it has been an ongoing situation. He's never done the hair follicle test. That went on forever and ever and ever. And now, as I'm understanding, the children are very frightened because of things that Dad has said. There's just a whole lot of issues right now on this.
Okay. All right, thank you. So I'm just reviewing the last hearing, which was on the 20th of December. That's what Ms. Rooks was talking about briefly. So just going back a little bit to December 6th, Ms. Rooks and Ms. Lawrence were present. There was no proof of service filed at that time. And Ms. Rooks said, hey, he was served. And then the court says, well, you need to provide at least 20 days notice, 21 days. And then told Ms. Rooks to reserve Mr. Clark with the documents. So that's on the 6th. So then I have a declaration of service that's filed on December 7th. It's dated as being signed by Mr. Phelps on December 7th, and an omission of the date and time of service of 12 empty as to the date or the day, and the year is filled in 23. So I'm going to make a finding that based on the context of the prior hearing on the 6th, the date of in which it was signed with the instructions to reserve Mr. Rooks, that it's a Scrivener's error on page 1, paragraph 3, with the omission of the specific day. So I'll find that there was proof of service effectuated and that Mr. Clark was in fact served on that date, and now I'll consider that a Scrivener's error.
Thank you.
Then that takes us to the 20th, where there was a discussion with Commissioner Carmi and the parties, where there's an indication that the court found that Ms. Rook's motion previously had not been served timely. And then it was set over basically today to allow for additional time. Mr. Clark said he received the documents requesting the modification of the parenting plan. And it was still too soon to make a ruling on it. And he planned to file a response. And then the court indicated that it would set a hearing in January on a Wednesday, and that any documents could be filed and shared with the parties. And the court indicated that Ms. Rooks needs to file proof of service showing 21 days prior to the hearing. So if we go back to the 7th of December, 7 plus 28, 7 plus 21 is 28. So the service is timely. And your motion is, based on what I read, the concerns of the bounty hunters and the arrest in front of the children, non-compliance with parenting classes, UAs, or anger management. I see no reason why not to grant your request. So I'm just going to find your proposed order, because I think you submitted a proposed order. Did you not, Ms. Rooks?
I did.
Let me find that. I'm not seeing it in my hard copies, my physical copies. So I'm just going to double check to see if it's in the case file.
Okay.
Do you know when you submitted that, Ms. Rooks?
It would have been on November 22nd.
Okay. So that's your motion. So you're making your request, and then you submitted information related to that request. And let's see if I can see if there's any submitted proposed orders. Yeah. And they did read Ms. Lawrence's update from December 5th related to the situations and concerns that she raises.
Okay.
However, I'm not seeing a proposed order, because what you're asking for, my understanding, is number one, there was a request, I think, from Ms. Lawrence to allow for additional hours to address the visitation issue for Mr. Clark. And the suspension of the visits of Mr. Clark until a future hearing. So so maybe we don't need a proposed order. Simply, it could be a fairly clean or simple bench order that allows additional hours to Ms. Lawrence to address visitation of the father, suspend his visitation in the interim. So I think those are the three items that basically are uncontested at this point.
Okay. I also had another question. Sorry.
Yeah, go ahead.
My children's school informed me that they need a court order signed by a judge stating that Mr. Clark cannot pick up the children from school. He tried to pick them up from school when we had the last restraining order put on the children and made a big scene. The school had to be put on lockdown and the children had to be put back into the classrooms until Mr. Clark was able to get off the property. He's very very violent and has a loud temper, and it scares the children, not just mine, but the other children that also attend the school as well. I don't think at this point he is, able to pick up the children at this time.
Okay, thanks, Ms. Lawrence. Any comments on any of the issues we've raised? Maybe you can start with your additional hours, about number of hours you think would be appropriate.
I think probably 10 hours should work. I'm hoping Mr. Clark can be very, very difficult to deal with, to run down, track down, so on and so forth.
Yeah.
So, but I think that 10 should probably do it because the bulk of all the background information is completed, obviously. Yeah, and I'm very concerned about this issue with Gareth trying to pick up the kids at school. The supervised visitation is not working with his mom.
Oh, absolutely.
Okay. All right. So at this point, I'll draft an order that encompasses the following: that I'll approve up to 10 additional hours of the guardian ad litem's time, county pay to investigate related to the father's visits. I'll suspend the father's visits and restrict him from going to the school or picking up the child from the school, and that the tax exemption for tax year 2023 is awarded to Ms. Rooks.
Thank you.
So I'll draft that and I'll get that filed with the parties. Ms. Rooks, do you have any additional items to address?
Other than that, I think everything that's fine.
Okay. Ms. Lawrence, any additional items?
No, Your Honor. Thank you for your kindness.
Okay, thank you. All right, that'll conclude that matter for today.
Thank you so much.
Yes, I am.
Okay, welcome to you, sir. Then D. Stillwell, are you on the line today?
Yes, I am, Your Honor.
Okay, welcome to you, ma'am. We're on today for indicated a GAL review. I think that may be related to payment, but I'm not sure. So we'll turn to Ms. Turnbull for added information on that, and then also a motion related to child support modification. So Ms. Turnbull, if you want to go ahead and share your input.
Sure. I think it was just mainly a compliance review. Ms. Stillwell and I have been in communications. She has some questions, and with the holiday, we have not been able to make contact, but we are working together, and so I would consider her in compliance. She's making an effort. Mr. Stillwell has returned his paperwork and payment, so no problem there.
Okay. That's great. I appreciate that. So, and it looks like there was a county pay for 50%, and each party was then responsible for the additional 25% each.
That's correct.
Okay. All right. Very good. And have those payments been made?
Mr. Butcher has made his. Ms. Stillwell is trying to make hers. So I think maybe we'll meet up in person for her to make hers in Longview or Kelso.
Okay. All right. Very good. So then that takes us to the child support issue. And I'm double checking with you, Ms. Turnbull. Do you have any input related to that? I would assume not, but do want to check.
Yeah, I don't have an opinion on child support.
Okay. And that's your last case, correct? No, if you wanted to sign off, or you're free to stay on. I'm not sure what you'd like to do, but I'd give you that leave if you want.
Okay, thank you.
All right, very good. All right, so that brings us to Mr. Butcher and Ms. Stillwell related to the child support. It wasn't addressed at the last hearing on the 6th. There was some additional information that was provided. And so what I'm understanding from Mr. Butcher, your viewpoint is that your net income is about $3,576. So around 5,500. Is that what you're representing?
Those net incomes don't sound current.
Okay. What's your position as far as your net income?
My net income yearly is around 70,000.
Okay. And that's net, not gross, correct?
Correct.
Okay. And so your gross income would then be in the range of 90,000 or something?
No, sorry. Let me rephrase that. Sorry, that is gross. 71,000 a year.
So you submitted I believe you submitted some paperwork related to your net incomes, correct? See, Ms. Stillwell, there's quite a bit of ambient noise that's coming from your microphone, and I'm not sure if you're driving or if there's something you could do.
No, I'm not driving. I was trying to look up some papers. Sorry.
It's okay. I'm not sure if you're indoors or outdoors, but there is quite a bit of ambient noise that's somewhat disruptive.
I am indoors. I don't know what it's coming from.
Sounds better now.
Okay. I moved my phone. That might have been it.
Yeah, sure. Okay. So as far as the child support issue, there was support worksheet submitted by Mr. Butcher where he indicated his monthly gross is about 5,400 and his monthly net is about 3,434. And that was filed back on December 14th. Does that sound accurate, Mr. Butcher?
Yeah, that sounds right.
Okay. So 34. Oops. And then Ms. Stillwell, as far as your gross income and your net incomes, what do you believe your gross and net is on a monthly basis?
On a monthly basis, I pulled up the paperwork, was $41.84 and 70 cents.
Okay, and that's as your gross amount, is that correct? Let's see, Ms. Stillwell, there's no audio coming through to my end, so I'm not sure if you answered, and I just was not able to hear. So it shows that she's still there. Her mute button is off. Ms. Stillwell, if you can hear me, oftentimes these issues can be resolved by a simple signing off and signing back into the call. So it looks like Ms. Stillwell is not coming back on as quickly as I had anticipated. I'm hesitant to proceed in any fashion without her presence. I'm going to have one additional case that I need to address this morning. Oh, looks like she's in the waiting room. Let's see if that's her. Making efforts to log on.
I am back. I do apologize.
No, it's all right. I'm glad you're back. Ms. Stillwell, can you hear me okay?
Yes, I can.
Okay, great. Thanks. We didn't do anything while you were absent. We were just waiting for you to come back on, assuming that's what would happen.
Yeah, the computer I was using died.
Okay. All right. So let's just, there's a motion to adjust child support. And the last I heard from you is that you indicated that your gross per month was 4,184. Is that accurate?
Yep, and 70 cents. Yes, that is correct.
And with your deductions for taxes and FICA and things like that, do you have an idea of what your net income is?
Oh, I did not write that down. I know per paycheck, I usually bring home about $1,300.
So let me ask you about that. So with a gross monthly income of $4,184.70, your take-home pay is only $1,300.
No. That was. Let me try and calculate it for you. I do apologize.
Mr. Butcher estimated your net income was around $2,000. Is that correct, Mr. Butcher?
Yeah, net. Yeah, I bring home per paycheck around 17, and I get paid every other month or every other week. Sorry.
Okay. All right.
Okay, I just calculated it. It's about $2,795.
2,795, and that's your net take home.
Wait. Yeah, because I make about $1,300 every 2 weeks. I get paid every other week.
Okay, so that's about 2,700.
Yeah.
Do your hours vary much?
No.
Okay, and what's your hourly wage?
It's about $22 and some change.
$22 an hour. Okay. And so the motion here is to adjust the child support calculations to reflect that Mr. Butcher his net income is $3,434 a month, and yours, split the difference $2,650 per month net, and that the new child support would be based on those figures. Mr. Butcher, does that sound appropriate to you?
It does. I will say it's not necessarily an adjustment, as there is no child support currently. And that's what we were looking at, is there's been no child support at all. And it's been one of those things where the objective was there was no child support, and we were doing the splitting the taxes because she needed the money to fix up the house, and I wasn't going to take money because fixing the house was for the kids. But there was no progress being made on the house until we came back to court.
Okay.
That is untrue. And you claim the all 4 children on the taxes the last 2 years when I was supposed to claim the girls.
I actually have my tax reports right here next to me, and I only claimed them for all 4 for 1 year. That was the 2021 year. And that was previously addressed in court back in November.
I tried to claim the girls on taxes for 2023, and it said that you had claimed them again.
No, I have
So,
the tax returns with me, so.
So the only tax returns we would have, I assume, would be the 2021 and the 2022, since we just concluded 2023, so we wouldn't
Okay,
have.
yes, that's my bad.
Yeah,
But
so
yes,
in 2022, who got the exemptions?
he claimed the girls the last 2 years. My dad did my taxes and I could not file them because it said that he had claimed them already on taxes.
Okay, and then Mr. Butcher, as far as 2022, who did you claim?
I've only claimed the boys for 2022. I actually have the tax reports right here in this envelope, if I can get them out. That indicates that I only claim the boys and I did not claim the girls. And I have the printouts of the paperwork with me.
Okay, and we're talking about 2 boys and 2 girls, correct?
Correct.
Yes.
Okay. And so going forward, the tax exemption, are we looking at solely 2023 or have 2022 taxes already been filed?
2023 have not been filed yet,
Okay.
but like I said, the last 2 years, I was not able to claim the girls. My dad did my taxes for me, and it said that they had been claimed already per him.
Okay. And so, Mr. Butcher, did you claim the girls in 2022?
No.
He's claiming he didn't, but
Who did you claim in 2022?
2022, I just claimed Elijah and Braden.
Elijah and Braden, you say?
Yes.
then why was I not able to claim the girls on my taxes? It said somebody had already claimed them.
Do you have that tax form there handy, Mr. Butcher?
Yeah, I'm trying to get the last one here.
Usually it's on the front page of the 1040. It'll list the
Yeah, I've got my tax forms for all the years. Because here's the 2021 where I did claim all 4.
Could you, once you find the 2022, could you just hold that up to your camera so we could take a look?
Yes. So I've got the form here from the because I had my taxes professionally done. And on the bottom there, it shows that I only claimed the boys.
Okay, so go back to that again if you could, please.
Sorry, right. I don't know. Hard to find the camera. But we circled where it says the boys' names are the only ones that I filed as dependents on the billing.
Elijah and Braden. Okay. All right, and that's for 2022, correct?
Yes.
Okay. And then your position is still well is that you, through your father and doing your taxes, he attempted to claim, but he couldn't.
Yeah, because it said that somebody else had already claimed them on their taxes.
Okay.
So my question is did John's wife claim the girls on the taxes?
No, because our taxes were done jointly. It was her and I are together in the one thing.
Okay. All right. So regarding let's go back to child support. We'll put the tax exemption on hold just for a second. With the child support, I'm going to set the net income of Mr. Butcher at $3,434. And I'll set the net income of Ms. Stillwell at $2,650 per month. And that will be inserted into the worksheet and then also a child support order. And I'm going to rely upon the moving party to help me in producing those documents. And I failed to note who is the moving party here. I believe it was you, Mr. Butcher. Is that correct?
Correct.
All right, Mr. Butcher, would you be in a position to use those figures, the 3434 and the 2650, and then create those worksheets and also the child support order?
What were those numbers again?
3,434 net income for yourself, and then 2,650 net for Ms. Stillwell. Then I'd like to set a presentation date where you would produce those documents, submit a copy to Ms. Stillwell for her review, and submit a copy to the court in preparation for the hearing. I'd like to set that for the 31st of January if we could.
We do have a court date on February 7th as well.
That would probably be better, avoid the 2 dates rather than coming back to court 2 days and just have it on February 7th. So let's have that. We'll set it for presentation of the child support order and worksheets on February 7th. And the effective date of the child support order will be January 1 of 2024.
I do have one more thing to ask. Lennox is not John's biological child, and I would like to have her back 100%.
Yeah, that the issue of the paternity of Lennox, that's an issue that's going to be, will have to be brought via a motion. There's an indication that Mr. Butcher is on the birth certificate, therefore he's the presumptive father. I did see the paternity testing, the DNA testing of an individual named Mark. So that's an issue that you'd need to bring a motion, and then Mr. Butcher could have opportunity to respond to that. So I'm not in a position to rule on that today because I think it needs to be formally raised via motion.
Okay, what motion do I have to do that?
It's just it's a simple, I'm not sure what you call it, but a motion to disestablish paternity.
Okay.
I think that's maybe the technical term. Then as far as the tax exemption, I'm going to, for 2022, and this may require, Ms. Stillwell, an amendment to your taxes, but I'm going to allow Mr. Butcher to claim the two children for 2022, Elijah and Braden, and then allow you to claim the other two children, Lennox and I'm not sure of the other child's name. I apologize. Alex. Thank you.
John will get to claim all 4 children. Can I at least just claim Lennox?
Could you repeat that?
For the year 2023, if he gets to claim Elijah, Braden, and Alex, can I just claim Lennox to help me get through because I am in so much debt right now?
Okay. Mr. Butcher? Do you have a position, Mr.
I would actually prefer if we just wait until we find out on the 7th on where we're going with the custody, because I think that any changes to the parenting plan will directly affect the child support anyways. So I think all in all, it should just be, we have to hold off on filing for taxes until after the parenting plan is decided.
Ms. Stillwell?
I'm fine with that.
Yeah, I think that seems prudent to address the child's or the parenting plan first, and then take a look at tax exemptions for the prior year. I'm fine with that. So it sounds like we'll be back on February 7th with the presentation of the child support order and worksheet, and also addressing the tax exemption in conjunction with the parenting plan possible adjustment.
Okay.
Ms. Stillwell, any questions?
No.
Okay. Any questions on your end, Mr. Butcher?
No.
Okay. We will see everybody then, and I appreciate everybody's input. We're here today on Mr. Camba's motion for adequate cause finding on a parenting plan, to modify a parenting plan. Looking at the service that was effectuated by Mr. Camba on Ms. Camba, looks like service was effectuated on the 17th of December. Does that sound right, Mr. Camba?
Yes, Your Honor.
Okay. And so between then and now, if I count correctly, today, because on the 17th, we'd count 1, 2, let's see, I've got the wrong year here. So when I counted it before, it was 16 days between then, the 17th of December, to today. And that needs to be 21, at least 20 days or 21 days, according to local court rule 88. So it says all domestic relation motions shall be filed and served upon all parties not later than 21 days before the time specified for the hearing.
So the documents were served on one day. It was on a Sunday, and then the say that that she was served, that document was turned in a few days later.
Yeah, good. I'm glad you raised that. Let's take a look here. So I'm looking at a document filed on December 18th, and it says, my name is Sabrina Clements. I'm not a party. I serve court documents on Desiree Camba, giving the documents directly to her on December 17, 2023 at 10:45 a.m. And it included the change of a parenting plan, custody order, summons, notice of hearing, proposed parenting plan, and she signed it on the 17th. Is that the document you're referring to?
I'm not, like, her stating when it was submitted, yes.
Okay, so it looks like, according to Ms. Clements, she gave all the documents to Ms. Camba on December 17. So that still puts us shy of the 21-day period. So we're here too early is what I'm trying to say.
Okay.
And so you're asking for some phase up time, and it's also some makeup time based on the earlier court ruling.
Yes, I was awarded makeup time because she was held in contempt.
Yes.
And I have still yet to see my son since she withheld.
Right. And then you submitted let's see, the date of this hearing was submitted for today. Yeah, I see that back in December. So she was given notice of today's hearing, being the 3rd of January at 9 a.m. She's not here. And so you gave notice of that. So she's not here. So the record will reflect that Ms. Kamba is not here. She was given notice of the hearing. We're here too soon. So what I'd like to do is set the matter over 1 week to January 10th. That'll get us beyond the 21 days. And then if she's not here at that time, then we'll take up, well, if she's here or not here, we'll take up your motion at that time. As far as going up to phase 2, having additional time, and also the makeup time during phase 2. And so, Mr. Kamba, what I'd like to do, and I apologize, it's taken us this long to get to your case for just a relatively short matter to address, but it's important. And so we'll set the matter over 1 week to January 10 at 9 o'clock in the morning for a continued hearing on your motion for adequate cause to adjust the parenting plan to allow for the phase up and the additional unsupervised visits in the makeup time.
Okay, is there anything that I have to do on my end?
Simply show up next week.
All right, thank you, Your Honor.
All right, thanks for your time.